The Honourable Wendy Kagendo is the Chief Magistrate at the Milimani Law Courts and a member of the Judiciary Committee on Elections. The Honourable Elizabeth Tanu is the Deputy Registrar of the Judiciary and is here. They're both here with us to talk about this. She's also a member of the Judiciary Committee on Elections. Good morning, ladies.
Good morning.
Your honours.
Good morning.
Now that, we are getting used to this language.
Yes.
Last week we had my lord. Today we have your honors. You're the ones you're always being called. Your honor, mimi niko na kitu ya kusema. Tafadhali. Sijui kwa nini nilishikwa.
Weka mkono chini, proceed and relax.
Relax.
Even the courtrooms, we are relaxed
Yeah,
these days.
nowadays you're relaxed.
Yes, yes.
Your honor, naweza sema kitu.
Yeah,
You see that all the time.
exactly.
Yes, it
Yeah.
does.
Why your honor? I mean, why is there a difference between honor and then the others are called Lord, Lord and Lady?
From the High Court, those are terms which have been there mostly to just give respect to the court. But we are trying also to do away with that. You remember after the 2010 Constitution, when its Chief Justice, the new Chief Justice said, no, we did away even from the wigs, the red robes.
Yeah.
So they're coming back, but we're trying
See,
not
they're
to
coming
have
back.
so much of that protocol, my lord, just your honor. But when I just simple Wendy, like today, it's Wendy, so that, we make it easy and we talk about things easily.
Right.
I don't have to be, your honor, this. But, in court, there's that respect, not for me,
For the
but,
office.
for the office.
Of course.
Yes.
Mheshimiwa.
Yes. For us who are in the administrative, wing of the judiciary, we'd rather, do away with your honor, with my lady. So because we want people to come and, ask questions and inquire and just have an open door policy. So we'd rather just be called Elizabeth, and yeah. But it's good to be called my lady. I mean, I aspire to be judge, so my lady.
Right.
And
You're looking forward?
Yeah, looking forward
sometimes,
to that.
Of course. It's a
Yes.
good thing. It's a good thing to get there. So we're talking about election petitions today. The judiciary has a committee on elections. Is this the same committee that's chaired by the Supreme Court Judge Mohammed Ibrahim?
Yes, that's the committee. He is a chairperson. Started way back in 2013, just as a standing committee. After the chaos, we cannot talk about petitions and elections in Kenya without mentioning 207 and what happened,
Yeah.
the Kriegler report. And then the judiciary was blamed for the chaos that was there. So we sat back and had a deep look what can happen. So when the 2013 elections were coming on, that's when the Chief Justice came up with a working committee. How do we go forward such that we are not blamed for what is happening? It was just a small ad hoc committee of some members. But now come 2017, now it became a standing committee of the judiciary.
Okay.
The chairperson then was the judge of this Court of Appeal, Mbogoli Msaga. But then this term, now that's the committee which is led by the judge of the Supreme Court, Judge Ibrahim. Yes.
So if you look at it now and say, so at a time whereby the judiciary would have been blamed for a lot of the chaos that happened after an election that, would have been seen to have gone bad. So does this mean that this establishment then was put in place as an answer or mitigating measures towards anything that may come about from the undesired result of an election?
First of all, the starting point is the judiciary does not prepare for the elections. We do not conduct the elections.
Sure.
We do not declare the elections. But an aggrieved party ought to have a place to go. And now in 2017, they're like, this judiciary, we don't trust them. We cannot take our grievances there. Let's go to the street. And that is why now we said once to give back that confidence in the judiciary. That's why the committee came, so that we prepare our judges such that we do not have matters coming to court. Either they are dismissed on technicalities. That's what happened before. If you remember the president.
Moi Kibaki.
Yes,
Moi.
and Moi. on that, I have to serve the president. You can imagine anybody, even you, the reporter, going to State House first to get him. Now, here is a document, sign here.
You're
It was
required in
impossible.
court to answer.
Then even, the size of the foolscap, it has to be done this way, on that way. So the very technical rules which were there were relaxed. So the committee is there to advise the judiciary, how do we handle petitions such that, we relax such rules, and also to ensure that they are escalated. I know they are hard. Now, many people ask, well, how come now with these timelines which are there? Why does the judiciary give petitions a lot of time? Why there's someone suffering in industrial area? Why is it, we are treating the politicians better than other people? But because of those injustices which were there, having a petition going for the entire 5 years, the person has served, for heaven's sake, they've already served the term. So even if I declare you the MP or the governor, it doesn't make sense. So to make sure that we have finalized this petition within a certain timeline, and Kenya is one of the few, countries where our constitution now set out the timelines because of how emotive our elections are. It had to be put down that, within this time, say like the presidential, within those 14 days, it must be there, concluded. Whether it's working or not, it's a question that is still
matter
out
for
there.
conversation.
Yes. So the committee now advises the judiciary on, this is the way the matters should be handled. Then we train the judges to make sure, that this petition must be concluded within these timelines.
What are the timelines? So we have the 14 days for the presidential. Well, there's 7 days to file and then 14 days to determine. What are the timelines for the other seats?
So for the parliamentary and the county election petitions, the timelines are, the petition should be heard and determined within 6 months. So the 6 months run from the date of declaration of results.
Okay.
So for you to file an election petition, you must do so within 28 days from the date of declaration. And results were declared on different dates. Before, we thought the declaration date would be the date of gazette, when you're gazetted as having been. But it is the date of declaration when you're given the
date the
certificate.
returning officer says,
Actually,
this is the winner,
yes.
and the certificate is handed.
Your time starts
counting.
running.
Okay.
For 28 days, then you must file that petition. So when you file within the 28 days, then you are given 14 days to ensure that you serve. And you can serve either personally or you can serve through substituted service. And substituted service means that you can even advertise on the national newspaper. And then thereafter, once you have been served, time starts running now against you as the respondent, and you must respond within 7 days. And then thereafter, the petitioner is given, time again, 7 days within which to respond to your response. And then thereafter, the court now has 7 days to call for the first pre-trial conference.
Okay.
And then now they are given 6 months within which to determine that petition. So as we are speaking now, petitions have been filed. Time has closed in respect to filing of petitions.
It's
other than the
28
party
days
lists.
Apart from Mombasa, of course, and Kakamega.
And Kakamega
and
and the other ones, yes. So so far we have 125 petitions that have been filed as of today, all filed within time. And the responses are going on in terms of, either IEBC or the winner now, the declared winner, responding to that particular petition. And the Chief Justice has gazetted the magistrates and the judges who are going to handle these petitions.
Okay.
Yes.
When we say 125 petitions have been filed so far, do you have a breakdown of
Yes, we do have a breakdown of those seats. And the 125 are exclusive of the party lists.
Okay.
Because you see the party lists petitions, their time is still on. Because now we count the 28 days from the date the IEBC gazetted the lists.
That's
so
a
they are
nomination.
still within time. But we have received so far 37 petitions in respect to the party list contestations.
So
the breakdown?
Yes, so for the breakdown, we have 12 for the governor position. We have 2 for senator. We have 4 for county women, representative to the
Women rep.
Yes, women rep. And then we have 77 for county assembly. 77.
MCA.
And 28 for the MPs.
And 28 for MPs.
Yes.
And time has lapsed. We don't expect any more petitions for any of these seats.
Yes, of course, apart from Mombasa.
Apart from Mombasa,
And
Kakamega, and the other Rongai, and
exactly.
the other
Yes.
the other parliamentary seats.
Yes.
If you compare this with 2017, this sounds like a very low number of petitions.
It is. It is. It
Yes,
is. Yes.
because in 2013 we had 188.
2013.
Yes,
Yes.
2013 there were 188. Then come 2017 there were 388. And now we are down to 125. So the numbers are definitely very low.
Very low.
Yeah.
This 388 in
Yes.
2017,
Yes.
were every single one of these cases adjudicated?
Yes.
And then ruled upon?
Yes, all of them
Within
were
6 months.
concluded.
Within 6 months?
There's one that fell through, but someone fell sick. But basically, we did ensure they went through within the set timelines.
Okay.
Yes.
I mean, just look, of course, numbers speak for themselves, but would you say then, if we're looking between 2017 and at 388, and then now 2022 at 125, is there still a judicial appetite amongst those who would essentially petition the court, or
What does
people-
it signify?
what does it signify?
Is it satisfaction with the electoral process?
or that people just have apathy
or
when it comes
apathy with
to
the judiciary?
the
think-
process?
I think the jury is out there, but what we noted in 2017, before the outcome of the presidential petition, the numbers were low.
Okay.
But after the election was
nullification.
nullification, then the floodgate opens, and there were so many. So that could be one contributing factor why the numbers are, a bit low. But also this time, we've had a lot of EDR from the very beginning, from the party nominations, from the registrar of political parties, and then the PPDT. People took their grievances, and a
Before
number
the
of
election.
before. So there was a lot of that outside the court. So once if they are satisfied from there, it could be then they don't have the need to dash to court.
Actually, before the election, there was all these mechanisms. The parties had in the nomination, in terms of nomination, there was the dispute resolution at party level.
Yes, yes.
There was a political party dispute tribunal
Yes.
that also handled matters
Exactly.
before the election.
Yes.
So you feel that this could also have contributed to, by the time we're getting to the election, people are happy with the process so far.
That's what we're thinking, that there was a sieving process this time. And we allowed the party mechanisms. Because when you look at the pre-election disputes also that came to court, they were low. They were 189. And yet in 2017, we had almost 300 also party pre-election disputes that came to court. But we attributed that to the fact that there were many, the parties opened up spaces where people could actually take their grievances, and we got to see that that mechanism was fully utilized by the parties themselves. And then, of course, many of the parties decided to go independent way, so not many of them sued the parties. So we saw these numbers also at the pre-election dispute level, where we had low numbers coming in. But basically, I think it is what Honorable Kagendo has said this time. In 2017, we attributed that to the fact that, the nullification was there, and the process basically had been questioned, the process in 2017. So even for the election petitions that came, when you looked at the issues that was, the running thread around all those election petitions were the issues of the process that IEBC had put in place. So with the decision now that has come out, maybe that is why it is low, from 388 to 125.
Right.
Yes.
It's actually a low number. I'm looking through my notes because I always have to try and remember these things.
Yes. Yes.
The number of elections that are held on the second Tuesday of August every 5 years, because I keep saying I'm counting them. There are 290 elections at constituency level, 47 elections for Senate, 47 elections for woman rep,
Exactly.
47 elections for governor, 1,450 elections for MCA, one for president. Total 1,882. From all those, we have had 126 petitions, including the
Yes.
one for president.
Yes. So when you look at it, even just against the numbers that you have run, so for 47 governor positions, you have only 12
12
petitions so far.
Yeah.
For the
47
senators,
senator positions,
two.
two challenging.
Yes. So the most for us is 77, but you see against what number?
1,450.
Yeah, yes. So it is a very small number.
But also the number of the candidates, for those positions, you've said the 1,882, there were 16,100 candidates. So, and the only successful ones could have been the 1,882.
Yes.
So 14,218 lost. So, those are the number of petitions, if people are really wanted
Yes.
to come to court.
Yeah.
It's about 14,000 petitions.
Yes. So the numbers are very low. But a study has also been done. I think even the trend, the courts are not, trigger happy, just out to nullify elections. Actually, just even from the last time, the ones who were successful in nullifying, just 1%. So, in as much like you come, but basically the courts are very cautious on that aspect. Yes.
So people are also feeling that, well, if I go to court, I better have solid grounds on why I'm going to challenge this. I better be able to produce proper evidence before court. Do you feel that also people are feeling, hey,
the standards
struggle.
are too high.
yeah, is the threshold too high for
Yeah.
you?
Because I'm just in addition to that question is that it cannot, from what we've seen, if anything to go by, you cannot come to court on a feeling. You cannot come to court feeling aggrieved and say, I am petitioning the win of such and such person. It should have been done in my favor. From with the threshold is still, and it's an assumption that it must be evidence provided and that you can see that there have been discrepancies. Are you ruling on, are these petitions being, adjudicated on raw emotion? Are they being adjudicated on hard evidence that we can see, testimony of people who are in the area? What thresholds are being set?
Petitions, just like any other case, by the time you come to court, you are the one who is alleging. So you are alleging maybe irregularities, illegalities. So you must prove, even in any other mainstream case, whoever alleges must prove. So you must have evidence, to show that, yes, we have a few issues that have come up. We ran across the 225 petitions.
Yeah.
Most of them are raising issues of, one, that agents were turned away from the polling stations. Most of the issues revolve around the failure of the KIMS kit. So, by the time you are alleging that there was failure of the KIMS kit, to what extent did it then affect your election? To what extent did that then affect the outcome? We have most of these petitions, there's a prayer for, you want scrutiny, you want a recount to be done. But by the time that you are actually saying that you want scrutiny and you want a recount to be done, you are alleging that they could be vote swapping.
Yep.
There could be inflation of votes at the polling station level. So you see, you need to then prove, you need to have witnesses come to court to show that votes were inflated at the polling station level. There was actually vote stuffing, at the ballot, at the polling station level. That is why you want a recount, because you're saying the people who turned out to vote are less than what was declared at the polling station level. So then you have to prove that. For me to nullify that election, you have to prove it, isn't it?
Because a voter is also allowed to come to court and petition.
Yes.
And they can come and say, I feel that I was denied the right to participate in this election. Is one voter not good enough? If one voter comes and shows you, definitely this is what happened. I went to vote on this day. Kim's kit, they told me I couldn't vote. Then they looked at the physical register. I was not found to be there, but I had checked, and here is my message on 70,000 from IEBC, which had told me that, yes, I am duly registered to participate in this particular polling station. Is that one enough to nullify an election?
Now, that takes us now to the famous Section 83 of the Elections Act, on now the grounds for the nullification. Of course, the court under Section 75, you can say, this one was wrong, it's cancelled.
Yeah.
But now, at what level There are the two, the famous conjunctive and disjunctive test. Was this election conducted as per the Constitution? Was it free? Was it transparent? Can I follow the process, how it went? The way you have said now, if one person is there, was I actually told, I cannot vote? It's not just the first person past the finishing line. You have to show that, all the rules which were there were followed. But now the other thing is now maybe something happened on that day. The way you said, maybe I came and the Kim's kit did not work, or maybe I was late. But now, did that your one vote, did it have an effect on the overall outcome? So which of the two tests, is it both of them? So remember, subsequently, the Katiba Institute case, when they went to court and, they're like, it should be the two tests. But then the matter went back to Parliament. And now the section was declared unconstitutional because of this, what you were discussing earlier, public participation, that even Parliament should engage in public participation. So since then, it's not very, very clear. But now, if a law is declared unconstitutional, we go back to what was there. So which is now is a disjunctive test. You can prove either of them, But basically, like I said, the courts are not, trigger happy to shoot down the elections. Actually, even the courts are mandated to even declare the winner, once, like, if an election offense was proved, or we've done a retally, and we see this one is the one who won, the court can actually declare now this is the person who won. But, you will not have that, from the Kalembendile case, like, no, let it go back to the people. Let them go and, and
let them verify again that this is
the
their
person,
choice.
So the court will not be, let's run with it. This is the person I have found to be the winner.
I'll just take a break at 8:30. We come back and continue looking at petitions, and especially what these petitions are. And when you talk about the Committee on Elections, what do you look out for? Does it go beyond just, a candidate coming to say, I feel that I was denied a victory? Or does it also go into the voters? Does it go into other institutions coming into court? Do you look at incidences of violence and other malpractices? All those you'll tell us. The Honourable Elizabeth Tanui is a Deputy Registrar and a member of the Judiciary Committee on Elections, and the Honourable Wendy Kagendo is a Chief Magistrate at the Milimani Law Courts and also a member of this Judiciary Committee on Elections. They are here with us this morning to tell us about the status of election petitions in the judiciary. And we already know there are 125 petitions that have been lodged before courts as a result of the August 9th general election.
This is the Situation Room, the only way to start your day.
This is the Situation Room. Eric Latif and Ndu Oko with you this morning. We are joined by the Honourable Wendy Kagendo from the Milimani Law Court. She's a Chief Magistrate there, and she's a member of the Judiciary Committee on Elections, and the Honourable Elizabeth Tanui, who is a Deputy Registrar of the Judiciary and also a member of the Committee on Elections. We are talking about the state of election petitions this year. So we have already been told 125 election petitions have been lodged, and anybody who felt aggrieved after the election had a number of days within which to file a petition in court. Counting from the day the returning officer says, and now it is my solemn duty to declare so-and-so as the winner, and handing over that certificate of victory to that person, start counting 28 days to file a petition. 28 days have lapsed for many of those, and only 125 filed their petitions. The only ones who still have a window open are the ones that held their elections days after 9th of August. This is in the case of the Governor, Mombasa, Governor, Kakamega, MP, Kachaliba, MP, Rongai, MP, somewhere west. What is it? Pokot South.
Pokot South, actually.
Yes. And there was also a member of County Assembly somewhere. So those ones have a window open. But so far, what we've seen is 125. Again, out of 47 governor elections across the country, 12 petitions filed, 2 for senator out of 47 elections, 2 for women rep out of 4 for women rep out of 47 elections, 77 MCA out of 1,450 MCA positions countrywide, and 28 members of the National Assembly out of 290 constituencies. It looks like it's a good thing. And you're saying many of these have been filed by aggrieved candidates.
Yes.
What do you consider a matter that should go into an election petition? Does it also include electoral offences? If, for example, people feel that during campaigns there were offences that were committed, there was voter bribery, or there was misuse of state resources, or there was hate speech in a campaign, does it also qualify as grounds for petition?
Yes, they do qualify as grounds. We will also give you statistics in terms of the number of election offences that are in court, and Honourable Kagenda will talk to that. But a number of these petitions have actually raised the issue of election offences as grounds, for why the elections should be nullified. I will just give you a list of them. For instance, when you look at the Busia gubernatorial election, one of the things that they are raising is voter bribery and violation on election day. So that there was violence on election day. They are raising that as a ground why that particular election should not be nullified.
Should be nullified.
Yeah, should be nullified. There are issues of, when you look at the Garissa gubernatorial election petition, they are raising the issue of election offences, which is gunshots at the Asal polling station, which left one person dead, a voter dead. They are raising that as a ground why that particular election should be nullified. They are also raising the issue of intimidation of voters by polling officials to vote for a candidate. That is an election offence on its own. And that is an election offence also as a right, that it can be brought, that particular person can be brought as an accused person to court. So those are the parts of the statistics we'll give on how many election offences have actually been filed from the 9th August general election.
And the nature of complaints.
Yes. So yes, it is true that you can use that as a ground for nullification of an election.
Is there any from Wajir?
Yes, we in terms of what grounds? Yes.
A petition from Wajir, and what
there
the
is
grounds
a
would be.
petition. Just if you can give me a few minutes as I hand over to
And the reason
Kagendo.
I'm asking that is because we all know that on 9th of August, an election did not take place in Wajir.
Yeah.
And it had to be postponed to the following day. And the grounds that were given by the IEBC on the day was the issue of violence.
Exactly.
So
exactly.
if an election takes place the following day, can a voter, let's say, go to court and say, you know what, there was violence on that day, and on the following day I felt too tired or too scared to participate in this, and therefore I feel that my right to participate in an election was then
subverted.
Yeah.
Yeah. We have a number of petitions from Wajir. I'll just give you the statistics now in terms of either governor or member of county assembly.
Okay.
But in the meantime, we can run the statistics in terms of election offences.
Yes.
You note where the petitions are, that's also the election offences are. And actually, we've also noted a notable, reduction in the number of the offences. There are not as many as the 2017. We had gone up to around 70. Now there are only 23 election offences. And they are not, as vicious, if I may say that. The ones have seen maybe a bit of the violence and creating disturbance. Those go to the gate, Kimaibiwa, and that one is, now if you can picket, but as long as you don't obstruct the process. So the offences which I've seen is maybe even voters who are trying to use other people's ID. The issue of bribery has come in. This time we've not had witchcraft. It used to feature a lot before.
As
an
offence?
Yes, an offence.
As a ground also.
It's an offence to use witchcraft.
Yes, if I go and I stupefy you and I come, I shake your
This
hand.
was my. I think this is also. I must ask because this is an issue. I was asking. Okay, so in terms of threshold, and that's what I'm saying. So then, what do you use to adjudicate? Because one would only assume that if then you were going to be able to say, actually, yes, this is something that has some ground, that means that the one who is hearing then must have some knowledge
on the witchcraft.
So do you invite
and,
like
so
an expert?
who then judges, and how who then
An expert
adjudicates over
witness
things
is
like
called
that.
by a court,
Yeah.
to come and say, so in this particular case, having heard what this person is saying, do you think they'll actually be bewitched?
Right. I mean, I know it sounds humorous, and that's the thing, because it's on feelings, isn't it? And it becomes then subjective. And then so how far within subjectivity then can you operate? And this is the question. Because if somebody comes, for them it is the reality, and we cannot run away from some of those things. It is a reality, is it not? That these are practices that are often held in very many parts in society. So if somebody comes to you and says that we feel that this person was able to win because they employed the tactics of witchcraft, for example, which is a reality for a lot of people.
True.
How do you adjudicate over that if you have no knowledge of said thing? How
You will have to
in
depend
cases
on
like that, how do
the
you do this?
witnesses, because you see there is a standard of proof for election petitions. Yes, it is on a balance of probability, so you don't have to prove beyond reasonable doubt. We know that it is higher than a balance of probability, but so long as you have witnesses who can actually then give evidence that there was that particular, practices,
Right.
then on a balance of probability, you can tell as a court that yes, they
Something
could have
actually
been.
happened.
Exactly.
Yeah, like if you have the actual witch doctor come
Or
and
the
say,
witch
this is what
herself,
I
yes.
did, yes.
Yeah.
The last time when you slaughter a monkey, you kept it
This
there.
person came and
you
they paid
dress
me.
it in a certain way, and I tie part of the monkey around my waist. And if I shake your hand while, I'm so well dressed with the monkey skin, then you go and you vote for me. But now you're like, how can you prove that I voted for you
Yeah.
because of whatever, transaction that we had?
And voting is by secret ballot.
Yeah, so
How do you even know how I voted?
So you can say no for all along. Now you can call witnesses, say for as long, these are my brothers and they know this is my family, and we knew they would not go this way. So something must have happened to make them go the other
I find that
way.
interesting. I think it's really interesting. And I think this is what we're talking about then in terms of an all-encompassing judicial system, whereby it doesn't, you're not precluded because of belief or societal practice.
Yes.
Right? But then looking at this, even as a registrars looking at those numbers, even as we look at this, Honorable Wendy, when we look at precedent that has been set, when these petitions are being brought, and we had a Supreme Court petition happening for the presidential election that went the way in which it did, those who may then fear that the same kind of actions would be taken on them, do you find that that would become something that is very real, whereby the threshold for proof is extremely high? You cannot then just come and bring anything before court and expect that you will be listened to and it will be judged upon in your favor. Do we find then that the way we see things playing out at the Supreme Court level will also bear impact on what happens with these other petitions?
Like I mentioned earlier, we noted last in 2017 when the election was nullified, the numbers went up. This time they are not as high, so that could be a consideration.
Yeah.
But basically, each judicial officer, each judge is meant to be independent.
Right.
Of course, they are bound by the decisions of the Superior Court, but to evaluate the evidence as it is, not what another judge said, not what my colleague Elizabeth is doing there, but what has been presented before me. So what the other part of JCE is, we've had engagement with even the other stakeholders, even LSK. Even as you are coming, this is the threshold. With this is what you should do. With the IBC, this is how you should be prepared, so that we just don't come to court. But on the other hand, we are not telling, there's access to justice. You come. The other aspect we looked at, even the whole issue of the cost, the filing fees and also the security of cost. Is it too much, the 100,000 now security of cost for the MCAs and the 500? There are those who have argued that, let's get rid of this so that people can come to court. But on the other hand, we don't want, it's put there so that, all busybodies, I'm bored a little bit here.
Let me go to court.
Let me just go to court. It's meant to weed that so that, you have a bit more more serious people who are actually coming to court.
And to enhance the efficiency, I'm sure.
Yes.
Because you've got 6 months and you've got to deliver justice to everybody, every petition that's been filed. So to make sure that the judiciary you're acting efficiently, remove people who could just be jokers. What is the level of entry or point of entry for petitions? We know presidential petition, straight Supreme Court. What about the others?
So for the others, for the member of county assembly, we have them filed at the magistracy courts. So the magistrates have jurisdiction to hear and determine election petitions in respect to members of county assembly. And then the rest, governor, senator, women rep, all those are filed in the High Court.
Okay.
So then those ones are the ones which are heard by the judges of the High Court.
Okay.
If you have an appeal, if you are dissatisfied, of course, with the decision of the magistrate, then you have 30 days after, the decision to file an appeal now in the High Court in respect to member of county assembly. And that is it. The levels of appeals have now been trimmed down, the way Honorable Kagendo said, so that you don't have, appeals going on and on and on.
So MCAs can only appeal at the High Court and it ends there.
And that it is.
Okay.
Yes.
And the others, when you lodge in the High Court,
yes,
you can appeal at the Court of Appeal.
to the Court of Appeal.
Can you go further?
You can go further to the Supreme Court, but for you to go to the Supreme Court, that matter must be a constitutional matter involving interpretation and application of the Constitution, and it must have been certified as a public interest issue, so that now the appeal to the Supreme Court is a special appeal. It's not a matter of right. Yes, it has to have something to do with the interpretation,
broader.
Yes,
it's not necessarily
and application
with regards to your
exactly,
seat.
exactly.
I'm asking that because we saw in 2017 to 2022, petition taken to court in the matter of Gatundu North. It went into the High Court, of course, then it went into the Court of Appeal. So it just kept dancing between one of those, where one declaration was nullify the election and then there's an appeal, and the MP served her entire term with the appellant still just trying to seek justice in court. What caused this, and what is the remedy for this going forward?
I think the issue is the appeals. Does it run consecutively or concurrently? So that if you have a petition which is going on, you remember a petition, you have 6 months within which to hear and determine.
Yeah.
So the question arises, if you determine this question on a technicality and you actually strike it out the way it was done for the Matakarua case, and then it goes to the Court of Appeal, time starts running for the Court of Appeal, now again 6 months. But you see, the Court of Appeal takes time to hear it because it has the 6 months within which to hear that appeal.
That's a year.
It then returns this matter back to the High Court. Remember, time for the High Court would have run 6 months from the date of declaration.
Yeah.
So by the time this matter is coming back to the High
Why
Court,
is it coming back to the High Court?
time has run.
From the Court of Appeal?
Yes, because the Court of Appeal has then made a decision that the High Court did not, add and upheld, and then the appeal that whatever it is the High Court did was not the right thing. So go back and have this appeal heard on merit. Okay. So when it comes back to the High Court, for purposes of it being heard on merit, time has already lapsed. So by the time the High Court judge is sitting to hear it, 6 months are already over. And you see, it is time which is cast in stone. 6 months, it's not flexible. I cannot extend time beyond 6 months. So that is what happened. Because it stayed in the Court of Appeal. The Court of Appeal had 6 months within which to decide. They decided it within the 6 months. Decided, go back to the High Court. By the time it's coming to the High Court,
the 6 months for the High Court
Have
had
lapsed.
lapsed. And there's no way they can extend.
Exactly.
We cannot reopen this
you
matter
cannot reopen. It's
because
cast in stone. It is a constitutional provision. 6 months. Yes. So
And
that
so-
is what happened. Yes.
So these are some of the issues also now JC is speaking up, like the MCAs, they could go all the way to the Supreme Court. Like remember last time, even on the party lists, we had some, you start with the party list, you go to the PPDT, you appeal. all the way to the Court of Appeal, and then bring it back as an MCA petition on party list, and now start climbing up again. So JC would pick on such an issue and now have the law amended so that, we cap and say, what Kenyans are interested in is to know who their leader is, not, so all these very many levels. And if we keep it too late, then it doesn't make sense anymore. So even some of these, the levels of appeal, then we can move them to back to Parliament, because that's the only way we can either enlarge or shorten the time which has been put there by statute or the Constitution. Yes.
So what I'm hearing basically is that conversation needs to happen within the JCE, and then going forward being taken up into policy, into law, on looking at these timelines.
Exactly.
Already, the judges of the Supreme Court have sat here, from their president to the chairman of the JCE, and they've said the 14 days for presidential petition is just not good enough. Now we are hearing again from you now who are practicing in the lower ones, that even these 6 months, if we start introducing other technicalities, then we are running out of time. Now the risk is taking us back to the pre-curricular.
Yes. No, we're
where
not
we
saying
go
the
back
6
into
months.
those days
The
where
6 months are actually sufficient. The issue is now with the appellate process. And I think we have managed that in this way. If you are appealing against a procedural issue and not a substantive issue, it doesn't mean that the petition, will be stayed. You file your appeal in the Court of Appeal if you have, for instance, you have sought an order for scrutiny and recount. And as an appellate, as a judge or as a magistrate, I have denied you that order. If you are aggrieved by my decision, then appeal. But that does not stop me from hearing the substantive appeal. You go ahead with the appellate process. I am hearing the appeal in the meantime. Or you have it as a ground of appeal. You will deal with it after I have had, this appeal substantively, so that I am within the 6 months and I'm not staying my proceedings for you to then proceed with the appellate process.
Okay.
So I think we have managed to deal with that. 6 months is sufficient for the lower court, for the high court to deal with election petitions if we manage the appeal processes.
Okay. Does, adjudication take into consideration implications on society? When we're looking at the Supreme Court issues, also saying, okay, we know that, the bench in its independence is going to look at the matters and weigh them such. Do you take into societal implications when looking at some of these things? That what would it mean if we have actually turned over a governorship, or if we turned over, the election of an MCA? Do you look at the implications before now this, rulings or judgments are made or considered?
Yes, the court, of course, should not be just, mechanical that, this is what is happening. We live in a society. I'll leave my courtroom, I'll go home. So we have to bear in mind, what is happening. The same even from when we even have the constitution or application, say like on the procurement of the electoral material.
Yeah.
If I stay this the entire process and take a long time, you see, those are some of the challenges. I'm like, if I say we are not proceeding because something was omitted, then what is going to happen? The timelines are running. But on the other hand, I can't say, it's business. I'm looking at, the final goal. It's a tricky balancing act where I want the law to be done, but I should not be so much constrained in my thinking without, like I'm just living in, in another planet. I'm not in Kenya. So I have to think, what are the consequences of this? Yes.
Ladies, we thank you very much for joining us today.
I have
So,
the numbers.
as you're good. Now that would be a very good ending point.
So I have, you had asked about the Wajir,
Yes.
the Wajir petitions. We have 10 out of the 125. 10 of them are actually from Wajir.
Where?
For governor, we have 2 petitions in respect to that position.
To the
So
governor
2
of
different
Wajir.
petitioners. And then for women rep, we have 1. And then we have 3 in terms of 3 for member of National Assembly, and then another 3 for county, for member of county,
County
assembly.
Assembly.
And then we have 1 for the other position. So 10 in total in Wajir. So
Wajir
out
alone.
of 125.
And
10.
add the election offences, of course,
Right.
that are there.
So we'll have a lot from that
So
particular
Wajir is actually
space.
going to be one of the,
Okay,
the
hotspots.
hotspots.
Yes,
When it comes to
yes,
petitions.
Yes.
There was also the issue of how we manage the filing process this time. I think it is good to mention that the filing process this time was changed in terms of we ensured and facilitated and enhanced our filing process so that you can file these petitions from the comfort of your office or home without necessarily going, to
a
Wajir to
courtroom.
file, and without necessarily having to queue in registries, to go there at night and to ensure that we extend time within the registries are operating. So the filing process this time was online, and we managed this across all court stations. So
Kudos.
Fantastic.
we managed that. Thank you.
You know, we are making big strides,
Yes.
very big strides as a country. And if we just sit back and appreciate what we do, pat ourselves in the back.
Exactly.
Thank you very much, ladies, for coming. The Honorable Wendy Kagendo, Chief Magistrate, Milimani Law Courts, and the Honorable Elizabeth Tanui, Deputy Registrar of the Judiciary, both members of the Judiciary Committee on Elections, telling us about the status of election petitions in the country. This is a Justice Thursday's conversation.